First, a long simmering battle between Philadelphia Mayor Michael Nutter and the city's largest union may finally be coming to a head, as Nutter has given the union what he says is the city's final contract offer. Though WHYY's Dave Davies reports some unusual Pennsylvania case law will make it hard for the mayor to impose his will on the unions.
The last contract between the city and AFSCME District Council 33 expired more than 3 years ago, but members are working under the terms of the old deal. Nutter says he's ready to give raises in a new contract, but wants cost-saving pension and health plan changes, which the union flatly rejects as givebacks. You might think that when a contract ends and an employer says he can't afford the old deal but can't negotiate a new one, he can say, sorry, these are the terms I can afford. Come to work if you want them, but I can't keep paying what you got before. Veteran labor lawyer Deborah Willig says Nutter can't do that.
He has no right to unilaterally impose what he couches as his last best offer.
When Willig says Nutter has no right, she doesn't mean it in the sense that it would be morally wrong. She means it's the law. In 1993, Willig pursued and won a court decision on behalf of a Philadelphia Housing Authority union. It held that as long as those employees were coming to work and negotiating, PHA couldn't legally impose new terms on them. Willig says that case set a new standard in Pennsylvania labor relations.
A public employer has no right to unilaterally impose a change in terms of conditions of employment during the course of collective bargaining.
So every public employer in Pennsylvania, every city, county, state, or school district now finds its workers can extend a contract indefinitely as long as they don't walk off the job or break off negotiations. Shannon Farmer, Philadelphia's labor lawyer, says the law in Pennsylvania is unique in the country this way. But she also cautions that every contract dispute and every court case is fact-specific. While Farmer didn't say it, it seemed clear when Nutter and his team announced their final offer Wednesday, they were building the groundwork for a new court case.
To be fair to our taxpayers, any contract must have ways for the city to better control our costs. And so we've proposed overtime reform and the right to furlough. Fairness for future taxpayers also means pension reform.
The dispute evokes memories of an epic 1992 labor battle between newly elected Mayor Ed Rendell and the same city unions. When the unions rejected Rendell's calls for benefit and work rule changes, he declared an impasse and moved to implement his final offer. That was before the PHA court case that changed the rules, so Rendell was successful in forcing a confrontation. After an 18-hour walkout, the union settled, and Rendell got most of what he wanted. That contract left a bitter taste for union leaders that's lasted a generation. Willig says for the city to implement new terms now, it would have to establish that negotiations are deadlocked as defined by the PHA court decision.
And it states, and it's particularly important in this case, that nobody can unilaterally decide what an impasse is.
On Wednesday, it sure seemed Nutter was making the case that an impasse exists because the union won't negotiate.
For 5 years, we've fought for fairness and reform. The union response, unfortunately, has been consistently no. We will not negotiate on those issues. We will not make any changes. The answer has been no.
Union leaders say they've never stopped talking and are making new counter-proposals. Nutter's given the unions 2 weeks to respond to his terms, and there appears to be no prospect he'll get a contract he'll accept. If he moves to impose his own terms, it will trigger a legal battle that's likely to last for months, if not years. Dave Davies, WHYY News.